Hello, this is Gabe Imperato from Nelson Mullins, and I'm joined today with my partner, Mike Ruggio. We were also expecting to be joined by our other partner, Lester Perling, but Lester came down sick this morning, so he's not going to be able to join us today, although he did contribute to the content of the presentation we're going to make on the enforcement implications of the COVID-19 government relief funds and regulatory waivers, minimizing the risks. As I said, I'm Gabe Imperato. I'm the office managing partner in our Fort Lauderdale office. I'm also team leader of the healthcare enforcement compliance and litigation team. Lester Perling is a partner in the Fort Lauderdale office as well and a member of that team. And Mike Ruggio in our DC office, who has a long time experience in handling criminal and civil fraud matters, is a partner in on that team as well. I'm going to turn it over to Mike now to lead the discussion and go through the PowerPoint presentation. I will provide some color commentary as we go along, and I'll wrap up the discussion with the last slide. If you have any questions while we're going through the presentation, please write them in on the section that you see for questions, and we'll take questions at the end of the presentation before we sign off. Mike, I'll turn it over to you.
Thank you, Gabe. Appreciate it. We've broken this presentation down into two parts, the first being the Paycheck Protection Program, and the second part being the Provider Relief Fund. As probably everybody's aware at this point, in April, the Paycheck Protection Program came on board and came active, and it's been very colorful since early April when it was initiated. The intention of the program is clearly to provide relief and support for small businesses. Let me go to the first slide. It is providing $659 billion for small businesses, which is a massive amount of money. And obviously there's a huge network that has been set up through institutions, financial institutions, to distribute these monies. The terms are all basically the same with each loan. It is a loan of 2 years, 1% fixed rate, 6 months deferred, but that is simply a format that is set up. A lot of the intention is that these loans will ultimately be forgiven. However, there's a number of requirements that are required to meet that. One of the first ones is that it has to be an organization of less than 500 employees. But also, and most importantly, for the purposes we start out with, is that there has to be a certification in good faith. The next slide. Certifications, and as everybody knows, certifications is just a word which basically requires that you're committing yourself to certain things to get an opportunity, and in this case, to get a loan. And the certifications here are basically pretty specific, and they're as follows: that the current economic uncertainty makes the loan necessary to support the ongoing operations of the business, that the funds will be used to retain workers and maintain payroll or make mortgage, lease payments, and utility payments, that the business does not have another loan under the PPP and will not receive another such loan for those purposes, and last, that the business has not received an amount under Section 7 of the Small Business Act, which would have been similar for usage for these purposes. Those are these general certifications that have to be made. Now, obviously, everyone's looking for the forgiveness of these loans, because that's really the economic nature of what's happening now. These businesses are on the ropes and having a hard time surviving. So for forgiveness, however, those certifications have to be adhered to specifically with regard to what these funds are used for. So again, the loans amounts that will be forgiven must be used for the following purposes: payroll costs, mortgages or rents, utility costs, and all employee or corporate leases that are maintained. In other words, maintaining the operation as it is, maintaining the employees as they are, and using those resources to maintain the business. Now, recent guidance, literally the guidance is coming out every couple of weeks on this thing to refine exactly what is involved in it. And recently, in the last 2 weeks, there's been more guidance with regard to the size of the loan and the impact. So if a loan is for less than $2 million under the PPP, it will be deemed to have been made under a good faith certification of need. So if you're making a loan under $2 million, there is a presumption that that certification has been made in good faith. Of course, those presumptions are always rebuttable and always can be subject to challenge, but basically that is the small safety net of a loan that's under $2 million. However, it's very clear from the guidance that's been put out that loans that are larger than $2 million are possibly going to be subject to government audits and review. And I think that a lot of these loans are larger than that. And I think that's a lot of the concern has come in. And Gabe and I are going to talk to you about several clients that have called us with regard to the concerns as they get into those numbers in those areas.
Actually, Mike, why don't we digress a little bit here to that now? A couple of weeks ago, Mike and I had to advise a client about their application for this loan. And the client had 4 affiliated organizations and was aware and was advised about the presumption that would come into play if the request for the loan was less than $2 million. And the statement by the Department of Treasury that for loans over $2 million, there will be audits. And the client, with the prospect of certification and the possibility of requesting more than $2 million and being subject to audit, needless to say, the client wasn't very excited about that prospect and ended up actually requesting a loan for 3 of the affiliated entities, but not the 4th one. And the total aggregate request for the loan was well under $2 million. And I think at the end of the day, the client was not comfortable certifying that he needed the money for the one entity, was more comfortable that he could justify requesting the loan for the other 3 affiliated entities, and in any case was under $2 million, and at least would expect to avoid an audit down the road under the circumstances.
Right, and I think was also interesting from that incident, I've had several others since that, Gabe, is that we're on the phone, not just with the CEO, but also with the CFO, the business COO operators. So it's these companies that are basically saying, look, we need the funds, we want the funds, and then there's the considerations of business operations, and then there's the considerations of the CEO, are we exposing ourselves? So it really is bringing in all of these parties and people to a decision to get these loans, but it really is the intricacy of what is involved and what's needed for these businesses to survive to get these loans.
Yeah, and you know, there were a couple of things that are worth pointing out from our experience with this. You know, the client reaches out and you know, a lot of times they say, well, can you give us an opinion? And you know, the answer is really no. This is an area that's uncertain. We can give you some guidance. We can give you an interpretation of the law, advise you about the law. You can document that. You can make a decision in good faith based on that, but we can't give you a legal opinion, and even if we could, it probably wouldn't be recommended that you spend the time and effort to do that. And then, of course, at the end of the day, the certification is made by the representative of the organization, the CEO usually, and only that person can ultimately, you know, make the certification. We can help with a board resolution to draft it in the right way, but at the end of the day, the certifying individual has to be comfortable that they can support the board resolution and that they can tick off the good faith reasons why they certified the need for the loan.
Right. So just following up on the forgiveness thing, obviously if the funds are going to be used for unauthorized purposes, the government is going to pay those amounts, and you could be subject to potential liability such as fraud for having used those funds for unintended purposes. And obviously the limitation of liability is not really limited. It could involve individuals, the shareholders, members, partners, et cetera, and management. So it's pretty wide open in these cases as to who's going to be involved in potential liability, whether it be criminal or civil down the road. So let's go to the next slide, which is enforcement. Are we able to get that next slide? There we go. There we go. Okay, so basically, just the enforcement of this is going to be very set out. All applications and certifications have to be made in good faith and be true and accurate. And of course, it's the responsibility of the borrower to ensure that those eligibility requirements are met before completing the certification. So just this in and of itself, what is made in good faith and what is true and accurate. And obviously you can imagine what is going to go on with regard to the consideration of these loans and what is going to be looked at in terms of documentation information to support the loans. And we'll get in that as we go on later, but that's the standard of the enforcement that's been set out. Failure to meet these requirements can and will expose entities and individuals applying to substantial criminal and civil liability. Criminal liability is basically knowingly making false statements in an application or certification or using those funds for unauthorized, unintended purposes. It's the standard liability in the criminal law, false statements and everything else that they're going to throw in the pot on that, on the intentionality theory. On civil liability, it's really going to track, for those of us who are a little bit older and remember the TARP program, which is the Troubled Asset Relief Program, where if you submitted claims for a loan and everything that was submitted was at issue or question or not true and accurate or not in good faith, it's going to be the activization of the False Claims Act and civil claims, which could be a huge fiasco for potential borrowers in this case. As everybody, or those of us remember, the TARP program generated something like $40 billion in recoveries from lawsuits and key term relators. This could be that or larger, depending on what happens with regard to what's submitted and what information is used and how it's looked at by the government. Under the
Mike, I got a few comments here. So, you know, when we talk about criminal exposure, you know, there's a standard of knowing and willfulness. I am aware of one case that came out of the District of Massachusetts recently, where the applicants for the funds essentially made up a business entity and lied that they had employees, and, you know, was obviously knowing and willful conduct that would warrant the criminal exposure. But civil liability under the False Claims Act is a much more pervasive and immediate risk for individuals and organizations applying for these loans. Just like under the TARP program, the plaintiffs and relators lawyers, whistleblower lawyers under the False Claims Act are already circling the wagons in this government funded program, and will be very vigilant about sniffing out potential basis for claims under the False Claims Act. And, you know, what that means, unfortunately, for our clients and those who apply for these loans is not so much whether they can defend a claim under the Civil False Claims Act, but whether they get pulled into one of these whistleblower cases in any event, because those cases can require a significant investment in defense whether they're claims with merit or without merit, just to work your way through one of those investigations and the ultimate resolution of the case. So it's a pretty significant risk, and there are obviously a lot of things that organizations can do to manage that risk, but I wouldn't say that it's 100%. I wouldn't say that it's 100% manageable risk.
Right, right. So really, a lot of caution has to be used with regard to these things, both from the certification as well as the intended use of the proceeds. They're very interesting, Gabe, because the case just came out in the Federal District Court of Maryland, Profiles Inc. versus Bank of America, where a class action was filed against Bank of America, claiming that they were using criteria beyond what the PPP provides to get the loan. And went to federal court, and the judge basically said, you know, you don't have a private right of action here under this, and the lenders can consider things that go beyond the law to consider making the loan. And in this case, the two considerations: did the bank have a prior relationship with this borrower, and the other one was it a veteran's business from a veteran? And it was interesting because in this case, the court said, no, that's fine. You can use other criteria beyond the simple specific terms of the PPP to make determinations of whether to or to not make loans. So I think we're seeing the beginning of a mass of civil lawsuits that are going to become out in many, many different ways.
Yeah, interesting.
So let's go to the next one, which is the Provider Relief Fund. And this kind of, in a way, mirrors, obviously, the PPP, but it's really directed at the hospitals and healthcare providers of the nation. And it is a very intensive relief package in the sense that it provides substantial relief. However, attached with it is substantial requirements. And under the general terms, there are 6 categories. 2 of them are general categories, which is the relief funds for general distribution of 20 and 30, $50 billion. And then there are targeted funds that are limited to specific groups. The first one being the FFCRA, which is the Family First Virus Relief Act, providing sick leave, providing extended leave for families, et cetera. So there's that. There's the Uninsured Relief Fund, which is specific for uninsured people and institutions. The next one is the high impact, those institutions that are going to get heavily impacted by the COVID-19, and the rural hospital provider relief fund, which is again a disproportionate impact on these groups. So there's both the general funds and then there's targeted funds, which are providing specific relief for those groups as well. So 50 billion and 50 billion. So the next. So again, this is kind of mirroring what we saw before, but the certification attestations, basically it's interchangeable. Here, obviously, there's tremendous focus on the funds that are received are going to be, there's going to be an attestation made confirming the receipt of these funds and agreeing to the terms and conditions of payment and confirming to the CMS cost report. So now you're bringing in the regulations of CMS with regard to these and the adherence to those rules and regulations with regard to the usage, the receipt and usage of these funds. Failure of a provider that receives the payment to comply with any of the terms could be a grounds for clear recoupment of some or all of the payment that's made under this fund. And all recipients are required to submit documents to substantiate that these funds were used for, number 1, increased healthcare related expenses, or 2, lost revenue attributable to the COVID-19. And those expenses or losses were not reimbursed from other sources. So clearly, again, that there's not another loan or another reimbursement coming in to fill in for what the purposes of the loan that you applied for were received. Next slide. So here's the reporting requirements. Again, much more intensive than what was required under the PPP. Specific reporting obligations are imposed under for more than $150,000 stimulus fund, not a lot for a healthcare provider, clearly not a lot for a hospital. Per the HHS terms and conditions, they must submit a report to the HH Secretary and to the Pandemic Response Accountability Committee, which is basically the OIG, and no later than 10 days after the end of each calendar quarter. So this is the OIG basically looking at what's been submitted to determine whether there was fraud, abuse, or waste under this reporting requirement. Clearly, this accountability committee is going to be a group that's going to look at, review, investigate, and/or activate potential investigations as a result of monies that were applied for and received. The reports must contain the following: total amounts of the funds received, the amount of funds received and expended. In other words, very heavy document tracking that has to be done on this. A detailed list of the projects and activities for which the covered funds were expended and used. In other words, the name of the project description, the number of jobs created or retained by the project or activity. That's sometimes tough to figure out. Information and or any subcontracts or sub-grants awarded by recipients in compliance with the Federal Funding, Accountability, and Transparency Act. That requires specific reporting requirements, very detailed information, which is going to have to be kept track of with regard to subcontractors and sub-grants, particularly with regard to hospitals. It's going to be a very involved process. So the tracking of these things that is required is an extensive amount of document information that's going to be required to be retained to be able to defend and or present in the event the Pandemic Response Accountability Committee gets activated or somebody else gets activated. So again, very heavy document reporting requirements. Okay, let's go to the next. The financial management standards. Each recipient must have a financial management system in place that provides the following. Again, identification of the accounts, what the federal awards were received for and expended for, accurate, current, and complete disclosures of all financial results from each federal award and program, records that identify the source and application of funds for federally funded activities. The records must contain information pertaining to those federal awards, the authorizations, the obligations, etc. Again, heavy document intensive tracking of what these funds were received, what they were going for, and what the intended result of them were. Effective control of the accountability for all funds, property, other assets. They must be used solely for their authorized purposes, as it was in the PPP. Comparison of expenditures with budget amounts for each federal award. Again, heavy tracking of what the expenditures were versus the budgeted amounts for those expenditures. And of course, documents, written procedures for determining the allowability of costs in accordance with the terms and conditions of the award, and assure that the recipients are spending the funds in a timely manner. Very
Mike,
document. Yes.
This sort of reminds me of what an organization would be expected to produce upon audit of their financial statements. So it's fairly significant accountability and control requirements.
Right, absolutely. And of course, there's a retention requirement. Obviously, you got to maintain these documents and records for an extended period of time. Here, the financial records need to be maintained for a period of 3 years from the date of submission of the final expenditure report. In the event there's any litigation, claim, or audit, it started before a 3-year expiration period. The records must be maintained until all litigation, claims, or audit findings involving the records have been resolved. In other words, you got to hold them for that extended period of time beyond the claims. Any real property or equipment acquired with the funds must be retained for 3 years after final disposition of the property. And when the records are transferred or maintained by HHS, if they go through the HHS system, if they pass through, if they're transparent with regard to the federal government having an access to it, this term of retention is not applicable to the recipient. So
yeah, Mike, I would say here that this 3-year retention requirement is regulatory, but we would probably recommend, nevertheless, a 7-year retention requirement because of potential collateral liability under different statutes, including the False Claims Act.
Right. Absolutely. Okay, next slide. The 1135 waivers. And these really are waivers, very broad waivers that are being provided to the states in a way to allow providers to provide the greatest flexibility in providing services and care for patients nationwide. So the 1135 waivers were issued by CMS to provide this flexibility, and they really cut across a lot of the traditional healthcare regulations and laws. One, obviously, to provide sufficient healthcare items and services for the needs of Medicare, Medicaid, and Children's Health Insurance Program beneficiaries. In the case of the emergency, with regard in good faith, that they be reimbursed and exempted from, sanctions. In other words, those funds are provided in a liberal fashion such that they're taken into consideration the emergency nature of what's being involved with regard to these healthcare providers. There are blanket waivers, meaning they apply immediately nationwide and with no further action required for submission by the providers. There's nothing that the provider needs to do to get access to these blanket waivers. The waivers are limited to circumstances described in each waiver, and there are numerous. The healthcare providers must satisfy all the conditions of the blanket waivers, and obviously that is something that has to be known and reviewed by the provider. Failure to comply with these requirements under the 1135 waivers and misuse, of course, subjects you, as always, to the False Claims Act. Next slide. And these are some examples of what the 1135 waivers would involve. The first one is kind of the open enrollment, the toll-free hotline for physicians and non-physician practitioners, establishing basically that kind of open enrollment to allow them to provide services in the context of the federal program system, such that they would not need to apply to get access to those reimbursement funds. Next one is the provider locations. In other words, breaking down those requirements that out-of-state providers need to be licensed in-state to provide those services. That's kind of being temporarily waived. And that's significant given that certain states have required, like New York, a substantial infusion of healthcare services for people that are out of state that are not licensed in New York. So it makes complete sense why that location waiver is kind of in place. The DME, medical administrative contractors may waive replacement requirements, such as face-to-face visits, a physician's order, or medical necessity documentation when using DME, prosthetics, orthotics, whatever, et cetera. That's significant because obviously there's been a history, and Gabe and I have done this for many years, where you have to have those either face-to-face requirements, the physician's script or order, and clear medical necessity documented for the requirement of the DME or whatever. And with that waived to a great extent, it really opens up the door. It opens the door both to providing that opportunity of services, but also the potential for abuse to come in here, where it will go beyond simply providing the services for COVID-19 and the emergency nature, but actually the potential of abuse with regard to this. And all of these do, obviously, in that regard. And the last one is the telehealth, where there's the CMS has issued waivers to expand the use of telehealth, especially the waivers of copays and deductibles for Medicare or Medicaid telehealth visits, which is significant. And obviously that's always been a no-no, but obviously here that's going to be waived. And I think Gabe, you had something on the telehealth.
Yeah, let me elaborate on this a little bit. So for those of you who might not realize it, Medicare had a telehealth benefit with coverage requirements, but it was defined by a coverage for patients who were in a rural area of the country in a facility like a nursing home, who could be accessed through a two-way electronic device with face-to-face capabilities between a distant a physician at a distant site to the facility where the patient was in the rural area. With the onset of the pandemic, CMS granted a waiver which allowed for telehealth services for office, hospitals visits, or other visits with patients when they were in their home and not limited to rural areas. These visits would be considered equivalent to in-person visits in a physician's office and billed and reimbursed by the Medicare program in the same way, with the same code and the same amount of reimbursement. They could be conducted by the physician interacting with the patient by phone, in many cases, by phone with a face-to-face feature in other cases. Even more importantly, CMS announced that they would not audit to verify that there was an existing doctor-patient relationship prior to the telehealth visit, or even that there was a continuing doctor-patient relationship after the telehealth visit, at least during the pandemic crisis. Medicare, prior to this waiver, did have two categories of telehealth, other telehealth visits, one called virtual check-in and the other one called e-visit, which could be done either by phone or through a patient portal. But of course, this expansion has expanded that even greater. The interesting thing about some of the touchstones of this waiver and the expansion is that it addressed the physician relationship and relaxed the requirements of the physician relationship in a way that almost contravened the types of cases we've seen brought by the Department of Justice in the criminal space against individuals and organizations who were attempting to purchase medical equipment, pharmaceuticals, and other devices through telehealth visits with patients, either through portals or through the phone, and where there wasn't a pre-existing established physician-patient relationship or an ongoing one, and those features actually were important evidence in DOJ's criminal cases, that some of which are still ongoing today. So there's a little bit of an irony to it, at least during the pandemic anyway. Oh, the last thing I will say about telehealth services, I noticed a week or 10 days ago that the CMS director, Seema Verna, stated in a news story that she thought the future of telehealth services under Medicare was a situation where the pandemic had let the horse out of the barn, and that we can expect that expanded telehealth coverage will be down the road even post-pandemic.
Right. Let's go to the next slide. So the next, obviously, when we're dealing with these waivers, one of the big things that you consider when you're dealing with physicians and healthcare is the Stark laws. And here we have Stark law waivers, which is going to be very interesting going forward because they've always been a fertile ground for issues of abuse and issues involving unauthorized financial relationships among physicians. So Stark waivers have been issued to protect healthcare providers that furnish DHS designated health services in good faith, but are unable to comply with one or more of the specified requirements under the Stark laws and regulations. And these really are laws and regulations that interplace with the physician and the regulation of their providing of the services, et cetera. And they're some of them are very stringent, but here we're getting a in good faith waiver with regard to many of those laws. However, it's very clear that the law is not suspended. It is not suspended. There's waivers, and the application of Stark to physician financial relationships is going to be considered with regard to the requirements of the national emergency of COVID-19 in the U.S. So one should not assume, and this is very important, that Stark is gone and it's waived completely. It's not, in fact. It's still in force, and the utilization of Stark waivers is going to be considered with the national emergency of COVID-19 and its involvement in those relationships which could involve Stark laws. And so that's something that needs to be kept very much in your minds and everyone's minds with regard to moving forward in this. A failure of a financial relationship with specific referral to satisfy one or more of these requirements would trigger the Stark laws as a referral or billing prohibition, et cetera. So there's really that potential exposure still there unless it falls into this specific exception of the waiver.
You know,
obviously, go ahead.
Mike, I would just say that as Mike mentioned, the Stark law is a very fertile ground for whistleblower lawyers to exploit against defendants. And while the waiver, I think, is appreciated, it puts a further wrinkle into what's a very complicated statute that makes it actually probably more complicated in its application. It's nice to have another item of defense if we're defending one of these cases, but if you're in that space, you're already in the soup. So I'm not so excited about the Stark law waivers, but nevertheless, it is what it is.
Right, and it goes without saying, you need to keep very specific, detailed records to be able to defend yourself in the event the government comes knocking with regard to what waiver you've used with regard to Stark laws. So let's go to the final page.
Oh, okay. Yeah, I think this is mine, right?
Yep.
Okay. So coming up, just
the next page. There you go.
There you go. So couple of general comments. During the pandemic, the Department of Justice did suspend operations in certain components of the Department of Justice, but that specifically and explicitly did not include criminal healthcare fraud enforcement and the affirmative civil enforcement sections of the Department of Justice and the United States Attorney's Office. So even though the U.S. attorneys are working remotely and not working out of their offices, they definitely are still working remotely in the Civil False Claims Act area and in the criminal enforcement area. And in fact, on top of all that, they have been required to prioritize investigation and presentation of cases involving coronavirus-related fraud schemes, and there have been a number of these investigations reported in the press. We also have heard in many cases the request by Department of Justice attorneys of cooperating federal witnesses to inform them of any coronavirus-related fraud activity, including hoarding of supplies and price gouging. And it's clear in several of the criminal cases we've been handling recently that if our client is cooperating and they have information in this space, that it's probably going to get them a little bit extra cooperation credit. Some of the criminal and civil justice system is delayed. There's been a reduction of grand jury proceedings, and the courts are operating remotely, as are many law firms and the Department of Justice, but it doesn't seem to have slowed down things significantly, maybe making it a little bit more manageable on a day-to-day basis, but these enforcement actions, investigations are proceeding. The Office of Inspector General of HHS has announced that they will not impose administrative sanctions for violating the Stark Law or the anti-kickback statute for certain remuneration related to COVID-19 pandemic on or after April 3rd. Essentially, they will not impose administrative sanctions in the areas where there are waivers under the Stark Law and where you can crosswalk that to the anti-kickback statute. Also, there was a general policy statement about the waiver of copays for patients seeking treatment during the pandemic for coronavirus-related ailments and disease. And I think that's about all we have for today. I don't know if I see any questions. Clara, do we have any questions on the? Oh, here's one. Will we receive copies of the presentation via handouts and not see them for download and not receive an email distribution? I think the answer to that is yes. Clara, can we make copies available to everyone? Yeah, I think the answer to that is yes. Let me see if there's any other questions.
That's right. Everyone will get that in an hour.
Okay. That's the only question I see.
Hey. Oh, just a thank you.
Okay. Thanks, everyone, for your attention today. I hope this was somewhat informative. Thanks to Mike Ruggio and to Lester Perling, who wasn't able to participate orally, but contributed significantly to the PowerPoint presentation. Good day to everyone.
Thank you.